just gonna do it like this. We're gonna record this bullshit on this video. And we're gonna call in. It is September 18th. The United States government is still derogating my Icwa and treaty rights.
Welcome to the audio conferencing center. Please enter a conference ID followed by pound. To continue in English, press 1. Para español, presione 2. Sorry, I can't find a meeting with that number. Try entering your conference ID again, and then press pound. Sorry, I can't find a meeting with that number. Try entering your conference ID again, and then press pound. You are now joining the meeting.
Good morning, this is the Court Clerk's Department J. I'll be doing check-in on those that are appearing through LA Court Connect. Do I have Muhammad Abdullah?
Yeah, right here.
Morning, sir. Do you stipulate to Commissioner Amironov, the bench officer presiding over your case?
What does that mean?
It means that the bench officer is a commissioner, and for the commissioners, we just have to get permission from both sides that he may preside over the case.
This is an Icwa case. Under Icwa, I'm not allowed to give tribal jurisdiction over the courts. You guys were supposed to transfer that back to the tribes years ago. So he has authority only to enforce Holland v. Bracken, U.S. Supreme Court.
Sir, I'm not an attorney. I just need a yes or no if you're stipulating that he may preside over this case. If you don't get... Go ahead.
My situation is governed by Article 6 of the Constitution and U.S. Supreme Court. So I limited it according to the scope of what's supposed to be going on. I can't give any more legal authority than that to the court.
All right, just please stand by. record while we do the MSC. Me on there? Is your Core Connect working?
I have mine working.
You know what? Teams might not be working. I'm just going to do it on the browser. Let's see if it works. No. Okay. As long as you see me. So, you don't see me? It doesn't have the courtroom? Yeah, it's not working. Try that. Let's see if it's doing anything. Oh, here we go. Okay. We did it. All right. Let's call matter number 3 on the court's calendar, 22 VEPT 00208, Parisha Robinson and Muhammad Abdullah. Do we have Mr. Abdullah on Court Connect? Mr. Abdullah?
Yes, can you hear me? Hello?
Thank you. Thank you. Can you... you're only appearing by audio. Can you please raise your right hand and confirm you're raising your right hand, and so we can proceed?
Okay.
Are you raising your right hand, sir?
Yes.
Sir, do you solemnly state that the testimony you may give in the cause now pending before this court shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you. And I'm going to note it's 9:08 a.m. There are no call-ins or check-ins by Ms. Robinson. Mr. Abdullah, this is the first appearance before me, and I'm the commissioner presiding in this department. Do you stipulate that I may act as judge for all purposes?
I don't want to waive. I'm an indigenous person, a native person, and I know this is supposed to be governed by Icwa Indian Child Welfare Act. I don't want to waive my rights. I give you authority in the limited scope under the Constitution of Deb. Was it Holland v. Bracken, U.S. Supreme Court? So just to protect myself from accidentally waiving my rights.
I am not asking you to waive any rights. What I'm asking you to do is stipulate that I may act as judge for all purposes. My role in the case would be governed by being appointed as judge in this case. So I cannot give you legal advice.
No, I already understand that. I'm tribal chief, paramount tribal chief. I don't need legal advice. This case has been dragging out for 11 years, and only one judge has enforced my rights, and nobody else is enforcing that judge's order. So just understand why I'm being very cautious, because many people have tried to coerce me into waiving my rights. So I stated what I need to state for the record. You can proceed.
So is that a stipulation that I may act as judge for all purposes?
Yes, because you're bound by law to you have to function within the scope of law. So yes.
Okay, thank you. We'll reflect that in the minute order. So we're here for an order to show cause for dismissal of the case in light of the fact that it's taken a long time to have service. But recently in this case, there was service effectuated. And so I'm just going to move this order to show cause to the 5-year. At 5 years, if this matter is not taken to judgment, this case will be dismissed under the applicable rules.
But you're not following the applicable rules. The applicable rules, I'm a native person. Indian Child Welfare Act, United States, 25 United States Code 1911A, tribes shall have exclusive jurisdiction over their children. I filed all the Icwa forms 10 years. Every year I file Icwa. I filed Icwa in 5 different states, and nobody's enforcing it. On top of that, when I first filed, Holland v. Bracken wasn't even in the U.S. Supreme Court. I filed before that. And then the U.S. Supreme Court came out and validated my rights. You're trying to derogate. That's exactly what I was stating, is that people are trying to coerce. This is not, you're not following the law. This is a trap.
Sir, can I,
you have to follow Indian
tell
Child
you
Welfare Act.
Sir, all we have here is an issue of whether this case can proceed.
It can't proceed.
As just a case. Stop, sir. Please, you can't speak over me and let me make. We have a record. You've said what you needed to say. All we're here on is an order to show cause to assess whether this case is dismissed under the 3-year rule.
The 3-year rule does not apply to Native American people. This case has to follow Native rights.
Stop. Okay? If there's any other basis to dismiss this case, the proper motion needs to be brought.
I filed the proper motions. I filed them. Every court is ignoring them. The last judge, I filed them, and he tried to also coerce me to file something that would terminate my rights. I filed exactly what the Bureau of Indian Affairs told me to file last time. It's in the computer. The judge ignored it. On top of, there's already case number CUD 19-666262 from Judge Charles F. Haynes, March 3rd, 2020, which he issued Indian Child Welfare Act, which was supposed to stop all these actions.
Where is that jurisdiction? What is that case number from? Which jurisdiction?
San Francisco, sir. And sorry about my emotional state. It's just, I'm sick. This has dragged out many years, and nobody's enforcing my rights. I've done all the paperwork.
So hold on. So wait, sir. Hold on.
Okay.
So there's a case out of San Francisco.
Yes.
And San Francisco County in California.
Correct.
Is that what you're saying?
And they ruled that.
And the case. Hold on, sir. Hold on. What's
sorry.
the case number again?
It's CUD-19-666262 I don't even know the name of the last judge. I don't even know your name, sir. But I gave these documents to the last judge that was tied to this case.
My name is Commissioner Amironov. Okay. I will tell you, I have reviewed your case file, and I noted that previously there were issues with service by Ms. Robinson, and you had filed a motion to quash, or you were intending to file a motion to quash, but you were waiting for service. And then ultimately, Ms. Robinson wasn't able to effectuate service for a while, and I will tell you that she's previously appeared before me with improper service, and most recently, she did effectuate service because back in December of 2023, if I recall, you had agreed to email service.
Okay.
So
well, were you the last judge? Were you the last judge from the last time that heard this case?
No. Okay. I'm reviewing the minute orders of the last judge.
The last judge tried to trick me to do motion to quash. I did motion to quash like he told me, but I was smart and I did what the Bureau of Indian Affairs told me to do, was motion to compel, because they were in contempt of court, not following Judge Charles F. Haynes and the U.S. Supreme Court's rulings on Native American children.
Okay, so listen, sir. I'm just telling you
But I know because I'm not I wasn't the previous judge until just recently when Ms. Robinson emailed you in August. The case didn't even move forward. So it's my understanding from your previous interaction with Judge Doherty, he was waiting for service to be effectuated so that he can then proceed on your motion to quash. Your motion to quash never needed to go forward.
Motion to quash is...
Okay. Please stop. Stop. I understand that you are agitated. I understand that you're emotional about this, but I'm trying to explain to you what I know. Okay? So that you can address me accurately and I could be better informed.
Okay, that's fine.
So
that's fine.
Take a breath. Stop.
That's fine.
Okay? So in December of 2023, while there was a question as to whether the court had jurisdiction over you, there was at some point an intention by you to proceed on a motion to quash. But ultimately, it didn't need to go forward because Ms. Robinson wasn't able to properly serve you. Fast forward to recently, in the past few months, she attempted to restart this case, and she continued to not be able to serve you until she just recently served you by email, only by virtue of the fact that you previously, with Judge Doherty, agreed to email service, because it's my understanding that you intended that once you were served to possibly file a motion to quash. So where we are right now is you were served.
Can I respond
That's
now?
it.
Can I respond now?
There's an intention.
Can I respond now?
Hold on, sir. So what I'm trying to tell you is now that service has been effectuated, the only thing that's subject to today's proceeding is whether service happened. That's it. So that's all this order to show cause is, that if Ms. Robinson had not been able to serve you within the first 3 years of this action, I was required to already dismiss it. She served you.
Okay.
So today, my intention is to just take the order to show cause off calendar.
Okay, can I respond?
In order to show cause. Hold on, sir. Let me finish what I'm telling you I'm doing today. And it's the limitation of what I can do today. On September 10, 2027, I'll be setting an order to show cause that if this case has not been brought to a conclusion by a judgment, then the case will also have to be dismissed. That's all I'm doing today. As far as any expectation of dismissing this case for some other grounds, the motion just needs to come before me, and I'll be glad to deal with any motion, whether you are seeking your motion to quash or you're going to, apparently I'm understanding that if there's another venue that is acted, like if San Francisco County is the venue that is acted, and there are orders, then perhaps this case just needs to be consolidated, closed up, and sent to San Francisco. But there's no motion before me with that information right now. That might be pertinent. And then if there's any other state or other legal entity that has made valid orders, then I will concede jurisdiction to wherever the valid orders are from. But none of that is before me today. We're only here on this 3-year rule assessment, and that's all I have. So anything else, sir? Otherwise, we're concluded for today.
Well, number one, you're violating my due process rights under the United States Constitution. United States Constitution, Article 6.2, treaty shall be supreme law of the land. We have treaty supremacy and supremacy under United States Supreme Court when they issued Holland v. Bracken regarding Native American custody rights and Indian Child Welfare Act. I have a right under the Penal Code of California to enact Icwa verbally in the court, which I'm doing so right now. You said that you would conduct yourself within the scope of the law. The due process for me is different than the other people in the court who are not Native or not Indigenous. There's a whole separate system for Indigenous peoples. This forces me to continuously have to prove that I'm a Native person every time I have this court situation, on top of the court is being negligent, on top of the negligence of the threat to my community, that literally I'm one of the last speakers of my tribal language, and the threats and harassment, physical violence, torture, peonage, coercion to try to trick me so you guys could try to get jurisdiction when you do not have jurisdiction. 25 United States Code 1911A clearly states tribes shall have exclusive jurisdiction over their children. Exclusive jurisdiction does not mean that you have any jurisdiction in this. The due process of an Icwa case, Indian Child Welfare Act case, is that as soon as the tribes and the native parents state who they are, you guys are supposed to change the process and begin to transfer jurisdiction back to the tribes. It's been 11 years and I keep getting threats and harassment from government officials when I try to state who I am and I try to teach my kids their culture. There's no reason for this case to continue to proceed legally. I did not agree to motion to quash. I filed information with many government bodies showing that the last judge was trying to coerce me into filing motion to quash after I told him I'm native. He did that to try to obstruct and derogate my rights. That's obstruction. You know what I'm saying? On top of that, I'm still trying to tell you again, I'm a native person. I'm a Louisiana Creole, Gullah Geechee Seminole person. I'm a paramount chief, the top of my community. And even with me and my genealogy, it's being disregarded. You know what I'm saying? I just want to have my rights. This is drug out too long. On top of the best interest of the child is not to be with the mother. The violence that has occurred, the threats, her instability.
Sir, we haven't. Sir, you're giving me a lot of information.
Okay.
But I can't really do
anything
with today because the only thing that I have before me today is whether under the statute for 3 years, if the process was not served within 3 years.
You went to law school, sir, and you have to understand that Icwa demands a competent judge. You don't seem, no offense, but you don't seem like you were trained in Indian Child Welfare Act cases, because as soon as I notified you, you're supposed to change the process. You're supposed to change the process to dealing with native parents and native children.
Sir,
this is not happening. And I'm also recording this call.
I'm more than happy to see your request in a written motion that's served on Ms. Robinson, and I will be glad to proceed on that. The only thing we're here today on is this order to show cause, sir. And all I have right now is that you've been served.
And I was coerced into giving you guys jurisdiction. I'm putting it on record. I did not give you jurisdiction. I limited my authority for you to have any say in this case to Indian Child Welfare Act, and you're not following that scope. So therefore, I did not agree to that. I never had any intention to do. Yes, it was. I'm recording this call. I'm recording this call. This is 29 minutes of me recording this. Okay. So
are you recording this, sir?
Yes, I'm recording this.
That?
Do you understand that I'm a native tribal chief and I have a right?
You cannot record these proceedings. It's unlawful to record these
It's unlawful
without a valid court order.
Title 18, United States Code 1091, you're engaged in genocide in order to destroy my community in whole or in part. A religious community, a national community, a linguistic community, that the forced removal of children, Article 6 of the genocide law.
I'm going to tell you right now, you must stop recording. You cannot record these proceedings. You have not been given.
Sir, are you going to enforce my equal rights right now?
I didn't hear what you said, sir.
Are you going to enforce Icwa and Deb Holland v. Bracken, United States Supreme Court, yes or no?
Sir, I'm not making any custody determinations today. And I haven't even gotten to that point in this case.
Okay, so you're incompetent. You're incompetent, Judge. The Superior Court does not have jurisdiction. This court is supposed to be transferred to federal court. It's supposed to be transferred to federal court.
This matter right now.
Okay, let's conclude it, because you're incompetent.
Order to show cause off calendar. Because
this is illegal genocide, 950T crime, war crimes. Deprivation of rights under color of law, 241, 242. Grave breaches, Pact of Family Treaty violation, King George III Royal Proclamation Line Treaty of 1763 violation, Treaty of Moultrie Creek violation, Louisiana Purchase Treaty, Article 6, I do not consent.
Okay. Well, you can bring your motion accordingly at this point.
I've already
There's
filed
been
multiple
service
motions and
by
you guys
way-
are ignoring them.
So if you don't stop, we're just going to conclude this matter. I've given you ample opportunity to present information about this order to show cause. You've gone well beyond the scope, and I can't take any action on what you're requesting because it's not properly before me on a motion for dismissal or quash or whatever it is that you're going to be seeking in terms of relief. The only thing that I'm assessing today is whether you've been served within 3 years, and you have been by virtue of a proof of service of summons that was filed on August.
Served in 3 years, but my daughter is 10 years old, and I filed for Icwa before she was even born. You guys are playing a game with me, and I'm not playing games with you guys. You guys are at war with my community, killing my people, bro. So I have a documentation of this. You're gonna be reported. I've already reported this to the United Nations, the International Criminal Court. Let's play. I don't care about you judges, man. You guys are fucking with my kids. Let's conclude. ما نعلى عليكم عادات المسلمين. Topas American. American le guerre law. Au site la terre indigène. Topa connaît. Topa connaît l'histoire indigène. People les chocs tribes. Les criminal tribes. Les chickasaw tribes. Putain
You are now allowed to
American.
unmute. To raise your hand, press
Fuck you.
*5.